We're here on case number D500910, Jensen versus Jensen. Counsel, please state your names and bar numbers for the record.
Thank you, Your Honor. Patricia Baccarino, bar number 5157, present and appearing with Caroline Jensen, thank you.
Joseph Cochoni, 10634, and Sabrina Dolson,
13105.
on behalf of Shay Jensen, whose appearance was excused.
Do we have any more than one witness left?
Not that I'm aware.
Well, offer proof would be, first of all, I realized Exhibit 1, you did review the first 2 pages that Bob Dickerson did say he received, got the letter, passed it to Joe. We just didn't move for admission of those, but I would move for admission of those now. That was
Wait.
first 2 letters of 1 are proposed 1.
Do you have any objection to Exhibit 1?
Yeah, it's hearsay, and it's being used to bolster.
It's correspondence between counsel.
Okay.
Yeah.
It's
her sending me a letter
the first
without
letter.
any responses.
The first letter we addressed solely because he made a blanket objection to the whole thing. And you said, okay, let's go letter by letter. Bob said, yes, this letter is addressed to me also. I did review it, and I told Joe to handle it, like a paraphrase. So it was about me asking for her full file and everything, like, so I could vet the issue. And so I think it is relevant, number 1, to what steps were taken before and after the motion was filed. Because there's been a lot of allegations that the timing, Bob Dickerson said yesterday, why'd she wait a year and a half? That's when I pulled
How is correspondence between counsel within the hearsay rule?
Because it's about a court statement offered for the truth of the matter. It'd be no different than if one of the parties wrote a letter.
Not every statement being offered for the truth of the matter asserted is hearsay. For example, correspondence between counsel is hearsay.
I believe it is hearsay.
How? Point me to...
I think I could offer it against my opponent as an admission. I just think by definition it's hearsay. It's being offered by the same party who drafted it. She's offering her own letter. I can't offer my client's own statements to support. That's the definition of hearsay.
Sure you can. Because if it's a prior consistent statement or a prior inconsistent statement, in fact, a prior consistent statement is not considered hearsay, especially by a party. But statements between counsel are not hearsay.
My objection is hearsay.
Okay, then I want you to point me to the provision in the Nevada Revised Statutes that renders it hearsay.
Hearsay defined. Hearsay means a statement offered in evidence.
I understand, and then there's all sorts of
Unless
elaborations.
Right.
Okay, but not everything. That's the broad definition with then statute after statute of qualifiers.
Exceptions. I don't think she's pointed out an exception that applies. If she could point out an exception that would apply to a letter between counsel.
And then if we're coming to that issue, which I will, I addressed
Except
it.
that Ms. Vaccarino is not offering it for the truth of the matter asserted. She's offering it to show what steps she took to resolve this matter before filing the motion.
That's one of the reasons why I was resolving it. The second, I was offering it that the recipient did receive it, verified it, which doesn't make it hearsay anymore. It means that it was what he did in response that I'm offering to prove to the court. Nothing. And that's what makes it admissible, because it's...
Mr.
And then you can
Cochoni,
eat peach ass to her if she lied in the letter.
the only time I don't allow for correspondence to be from counsel, because sometimes they make things clear and they do assist the court, the only time I don't let them in is if they include compromise negotiations. But if there's no offers of compromise here and it's just a letter of demand, a response to a letter of demand, then they come in. And they do not fall under the hearsay rule. Because, by the way, as attorney for your client, you're representing him, and therefore they are prior consistent statements. Anything Ms. Vaccarino says to your firm is a representation of what her client is saying, and it's a prior consistent statement. So therefore, your objection is overruled. Let me read the letters.
Your Honor, I would just ask if you read the letters and realize, because I think when you read them, you're going to see this goes far beyond what she's representing to you.
All right, then I'll read.
Why
do you want me to look at the letters?
I think you'll find them to be
Okay, let me look at the
objectionable
letters.
And I was referring initially to the
By the
first
way,
2 letters.
which of these letters are already attached to the exhibits? Are attached to the
almost
motions.
all of them, you're right. The initial ones, before I followed the motion, all of them. And one other thing, Your Honor, there was no objection to these letters when they were
All
offered
right,
in
let me
discovery.
take a look at it. I'm tempted to make a statement to council. I don't know if this is of any benefit, but I'm gonna say it because it may well assist them in how they present the rest of this case. I have been an arbitrator in the past and a mediator, spanning all the way back to the early 2000s, okay? Prior to that, I was just a negotiator. I was a Supreme Court settlement judge for years. I was second class they appointed, okay? Along with Judge Johnson, Ms. Cunin, there was that second group they appointed in like 2008 or 2009. That's all me prior to being on the bench. I was a court annexed arbitrator. I've been in the whole field for many, many years. One of the styles that I have adopted as a mediator is what I call shuttle diplomacy. Okay? In other words, and if you ever have one of those judicial settlement conferences, you can anticipate this is how I'll handle it. I don't have everybody in the same room. I don't believe in it, for the record. I don't think it's productive. That's my style. I'm not saying that somebody else's style might not work for them. My style is shuttle diplomacy. What does shuttle diplomacy mean? That means I have repeated ex parte conversations with attorneys and sometimes with litigants themselves. Okay? All ex parte. But ex parte doesn't apply when you're talking about mediation because mediation anticipates conversations that you may have with one litigant or the other with regard to their position on something. In fact, the advantage to a mediation as opposed to a trial is that whoever's acting as the mediator, whether it be a judge or an attorney or somebody who's a professional mediator, we get to hear stuff that judges can't hear when they're trying a case. So I'll hear, for example, what the parties think is a weakness in their case. Or I may hear what they really want and why, and what's going on in their head when they are proceeding with the mediation. It's very productive to know all the things that are going on in each litigant's mind, because then it enables me, more often than not, to help them fashion a middle ground. Okay? Mediators do have ex parte conversations. And in fact, we hear stuff that we might not otherwise hear if we were trying a case, but it doesn't make us lawyers. Okay? It doesn't make us lawyers in a case. It makes us mediators that are trying to figure out what the issues are and how we can fashion a resolution of all the issues. People come to mediators because they can't agree on everything. And what a mediator gets to do is find out the deepest, darkest reasons why parties are having conflict. Because sometimes conflict has less to do with these basic legal issues, and oftentimes more to do with other considerations. But if we as the mediator understand the considerations, then we can be more effective. So I do it shuttle. The only time I have people in the same room, frankly, and that's my style, is when it's being proven up. Because for me, it's more effective. I think that sometimes when you've got people going into mediation, they're still hostile with each other. The reason I'm saying that, and again, I haven't heard the evidence yet, but merely because one of two parties to a proposed mediation has a private conversation with a mediator isn't necessarily going to alter the roles the parties are going to play. Okay? I thought about this a lot yesterday, which is why I'm saying it today, so that I want to be perfectly clear that that's one. And number two, if somebody is going to perceive somebody as somehow their lawyer instead of their mediator, it has to be a reasonable anticipation and not just something that's unique. It's got to be a reasonable perception as opposed to an individual perception. If we went by individual perceptions in so many areas of the law, people would be suing each other left and right, and cases would be chaotic. So we've developed a reasonable person standard. By the way, when I was practicing originally, it was called a reasonable man standard. It's not. It's a reasonable person standard. And it is one that is applied to a person's perception of what's going around them. If it's something unique to that person, then it may well not be as persuasive to a court if it's found to be not what a reasonable person would perceive. Okay? I want to say that. I do want to hear from your client, but I want there to be that context there. Because I thought a lot about what Mr. Petit testified to. Counsel, I thought about what Mr. Petit testified to because I found it of assistance to the court. If there is something else, I want to know it. I want to make the right decision. Okay? And I want to make it perfectly clear that this is a decision I make based on the law. And I don't want anybody to perceive that I'm making a decision based on any past relationship I may have had with somebody. And if that's the perception, I'm sorry, but it's wrong. I am on the fence on this. I want you to know. Mr. Petit sent me in a different direction, frankly. But then I thought about, like I said, I spent some time thinking about this case. I thought about it yesterday, last night, thank you very much.
Me too.
And I went back to the idea of what's a mediator and what do they do and the different mediation styles and how that's done. And, again, I've never mediated between two unrepresented parties. But as I'm looking at that, so I want to hear from your client because I want to know what she has to tell me. But please bear in mind that if this is in the context of a mediator, simply a private conversation does not necessarily alter the roles the parties are playing, because mediation is, in my mind, so much about private conversations you have with the parties.
It looks like a lot of these comments, if I may respond, Your Honor, or I don't know.
Well, this wasn't requiring a response. I wanted you.
Because it seems like it's directed at us that you were leaning towards granting the motion, and now
Well, no.
the things that Mr. Patty said are somewhat
The defendant hasn't contended that he's had any private conversations that caused him to believe that Mr. Dickerson was anything other than a mediator.
That's not even the factual analysis, private or not. It's the content of the conversations from her
And that's
perception
what I'm
how
going to
he
have to
acted.
hear
So
about.
we agree with you. So the whole fact that he's saying the whole three-way, two-way conversation is based on whose recollection is better or who's conjuring up a story now.
I get
And
that.
that's why those facts are important.
But I wanted you to understand, put in context my understanding of the role of a mediator and how this set of facts could or might not alter how I perceive it and whether or not I think that there's a prospective client relationship. Because that's my understanding that you're relying specifically on 1.18.
No, and in fact, Mr. Patty was wrong yesterday because he said there is no rule for Nevada that applies to mediation. Do you agree with him? sitting here today
Well,
because
no,
it's cited in his
He's
brief.
saying, wait, no, the
Well,
rule,
that's the
the
thing,
question
he's
you
not an
asked,
expert on this.
we have, I said, this
should
came
know.
up, I said,
He's
we
not an
have many rules for arbitrators, but do we have a code of ethics?
1.12.
What?
1.12 also applies, has been cited in the defendant's brief, and when I asked him about it, everyone refuses to go whether this guy was only being a mediator, almost a mediator. Written notice is always required
Let me
promptly.
look at it, Ms. Vaccarino.
I'm just saying, like, they've missed a few steps that caused this motion. Written notice should have been given to both parties, whether he was a mediator under 1.12. So Mr. Patty was not abused. He clouded the
Let me
record.
look at, Ms. Vaccarino,
us.
do you want me to look at it or not?
Please, thank you, 1.12. Because I asked him about it, he didn't want to comment when we left.
Okay, read the rule.
Okay, so the point would be that I'm hoping that you're gonna put as, they didn't want him coming because they said, you're not allowed to allow someone else to take over your province of giving an opinion as to the facts. The defendant came back in and said, I agree, Mr. Hoagie told us that if they come to court, they're not opining on the facts, they're only opining on the rules and the comments. And then all of a sudden, he comes in, you probably hate to say it, everyone loves Bob, I know that. It maybe shook it, no one wants to testify against Bob. You know, my client's here is a woman that she was trying to speak truth to power. Nobody gave her notice of this. If it would have been done a year and a half ago, this could have been avoided, and I want the court to please, as you focus on this, focus on that. You will.
Okay, you've
interpret
asked me,
these rules.
just, because I'm gonna do a little bit of a,
Okay, because I'm
Colin.
concerned that he backtracked, could have been, didn't know
I
the
wanna
duty
do a
of
little
loyalty.
colloquy with you on the rule.
Okay,
Is it your position,
he's a third party neutral, if
is it
nothing
your
else.
position that Mr. Dickerson participated personally and substantially as a mediator?
No, he participated
Well, there's an and there.
substantially as a third party neutral, which
Well,
is
how do
in
you get
here,
to substantially?
and as a legal advisor to my client, which she will testify to. But for the legal advice she received from him and Marshall Willock, she wouldn't have made the agreement she made the day after getting legal
Well,
advice.
I don't care what Marshall told her.
Well, you should, because she had two bars to compare it to. She heard advice from Marshall, because you asked him too. Did you speak to anyone else?
Okay, well,
So
let's
this will
hear
be
it,
the offer of
let's
proof.
hear it, but I want
We'll
you to
hear the
make it
evidence.
perfectly clear that the only time that a mediator under this rule
He said,
cannot represent a party is if they participated both personally and substantially, which to me begs the question, if the mediation never happened, where's the substance?
okay, so what about other third party neutral?
What?
So if you are a law clerk, an adjudicative officer, an arbitrator, mediator, or other third party neutral.
Yes.
He either acted as a third party neutral, because he didn't do really anything yet but give advice, according to my client, and or 1.18 prospective client. In the end, if he thought he could have, should have, maybe almost was an attorney, maybe almost wasn't a mediator, he should have given written notice, don't forget, I knew you over the phone, and gave whatever he perceived it was,
All right,
and
well,
she
let's
could.
hear it.
That's the.
Let's hear it.
So with that, Your Honor, I think you said, if I have to be called as an advocate, under
I'm not calling you.
Rule 3.7, I would be allowed to be called if my testimony relates to the nature and value of legal services in the case.
No.
That's Rule 3.7A2. So if I can't get the rest of the letters in, one about her attempt she made under your rulings, I will request that if you have to get the flat.
Why don't you call your client?
Thank you, Your Honor. So, go ahead, Caroline. Thank you, Your Honor, for your thoughts on the case.
Okay, please raise your right hand. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. Please be seated.
Please state your full name for the record.
Caroline Ann Jensen,
And where do you currently reside?
Las Vegas, Nevada.
And can you tell the court when you perceived that there could be a conflict or an issue of disqualification with Bob Dickerson's firm handling Shane's case in this matter?
Objection, lack of foundation leading.
When did you first?
Overruled.
I received a request for a bunch of interrogatories and other information from the defendant, and
From
as
what?
the defendant requested a bunch of interrogatories, and then I think admissions is the other legal term. It was about 40 different items in 2 pages. One of them was all my previous emails between me and my ex-husband. And as I went through that, I noticed that some of them came from Bob Dickerson. It was early April, or beginning of April
Of what year?
of 2019.
Okay. And upon making that discovery, what was your thought when you saw Bob Dickerson's name attached and you put the two together?
It felt extremely inappropriate. He knew what my issues were going into our divorce that are still not resolved today, 5 years later. We talked about the things that
What?
we're dealing with now.
What?
Mr. Dickerson and I discussed my main issue, custody, and also financial issues, and that's what we're dealing with right now.
And
Counsel, you're gonna have to go more specific than that, that's
yeah,
for sure.
I'm getting foundationary information of how she felt when she read it, and then we're going to get into detail of what you did actually from your what happened on the dates in question. However, did you just ignore it or sweep it under the rug, or did you take action on your discovery in early April of 2019?
No, when I discovered it, I sent it to you and your assistant and asked you if it was legally kosher, I think might have been my terms.
Okay, and did I give you an immediate answer and or blow it off? What did I do?
I think it was within a week there was a response, but also I sent you 20 different emails with 200 pages worth of evidence that
What
was
our
requested.
idea? Did we run to file a motion, or did we want to get some information from sources before running to file a motion?
We were looking for information, and
Like what?
then while that happened,
Okay, go ahead.
well, you recommended that I contact the bar council to see what they thought on the situation.
Okay.
And
Did
then,
I discuss with you what rules I thought could apply to this factual scenario?
yes, you did.
Objection, leading.
You are.
And what else what did you give me authorization to do in response to this disqualification issue that you discovered?
I wanted you to contact bar council on my behalf.
Okay. And did you also give me authorization to contact someone who I think is a mentor, attorney in town, to also give advice regarding the fact pattern?
Yeah,
Objection,
absolutely.
leading, relevance.
Sustained.
Who else did you authorize me to contact on your behalf regarding the legal issues in dispute today?
I wanted you to contact someone that you felt would have information on that law, and
Okay. And do you remember who it was? I wrote a letter to him actually on your behalf.
I can't
Objection, leading.
Do you remember who we wrote a letter to?
remember the name, but
And
Objection, lack of.
Okay,
so
Ms. Vaccarino,
What-
you are leading your witness a great deal.
okay, I'll move on and do better. Can you please tell? Okay.
Okay, go ahead, ask a question that's not leading.
Tell the court why you felt that was not, you said, legally kosher, and tell the court what you believe you shared with Bob Dickerson on July 2nd that made you feel this way.
I didn't feel it was appropriate because I felt like I provided him substantial personal information. I was extremely uncomfortable talking about it in front of my ex-husband, and also he had had time alone with Mr. Dickerson on the phone, and I wanted that time to myself as well. So I had a private conversation with him for 20 to 30 minutes.
During that conversation, did you only give him information, or did you receive information back as well?
I gave him
Objection, lady.
information.
Sustained.
Tell us what else happened during that conversation, as far as what Mr. Dickerson specifically told you.
I talked about my ex-husband's resignation in lieu of getting court-martialed. It had to do with significant shady dealings, for lack of a better word, scams. I had recently found out that my ex-husband opened 13 different business credit cards in my name, and I really didn't trust anything that he had to say, and I wanted to discuss that with Mr. Dickerson. He lost his military retirement. We both had the same entitlement to retirement. He lost his, yet he wanted to claim mine. I still get emotional about it because it was a really, really tough time. And then I also discussed the main thing is that I was still traveling with the Thunderbird, so I was gone every Thursday to Monday, and my ex-husband would then also travel for Delta. When I was home Monday through Wednesday sometimes, we had a very I guess an abnormal work schedule, being two pilots, me being home, once a week, and him, I guess, he was gone a couple times a month. But that was all about to change. So I had a non-flying assignment coming up to Washington, D.C. that my ex-husband and I had agreed together to go to a year prior to when we decided to dissolve our marriage. And I was not able to get out of it, and I felt like he was leveraging that against me. And I wanted his advice. And
Whose advice?
Mr. Dickerson's advice.
And did you ask him for his advice
I
on
did.
the custody issues?
I did
Tell the court how he responded to your recollection.
He told me that he didn't think that the way things were set up, that I would be able
You didn't think what?
the way that our present situation was with our work schedules, that I would be able to get primary physical custody. And he also told me that he did not think that a court would grant me my retirement, since we had been married for more than 10 years and it was joint property, despite the fact that, he was not a stay-at-home parent. He had his own career. He, had the same education that I did and a great career, but he still said it wasn't worth it for me to go into court to ask for me to be able to keep my entire military retirement.
How did you respond to him when he said when you told Bob you wanted to pursue primary custody?
I was really disappointed, and I went over the facts again,
I'm sorry, what?
I was very disappointed that he said that to me. I was done flying in November.
Did he explain to you any rationalization, or just the court wouldn't award it?
Objection, lady.
I'll rephrase.
You know what?
Did he
I'm going to allow it.
Yeah, I
Overruled.
was going to just end off the last piece. Did he explain the rationale?
It was based off of his legal experience.
And did he, did you ask him for any further information regarding how the court would address the custody issue?
I don't recall that specifically.
Okay. And what other advice did you receive from Bob that day, from your perception?
Objection, asked and answered.
Overruled.
I'm sorry, say that again.
From your perception, what other advice do you believe, this is your chance to tell the court, what other information you may have received from Bob, or did receive from Bob, that you consider legal advice that helped you with what we have admitted as Exhibit 7, the letters regarding so?
We did discuss our finances. He had discussed it previously with my ex-husband. When I look back at that letter, I think he skewed our incomes. So based off of some of the things that he said from conversations with Shane, I felt like he was also skewed.
What did he tell you about? What did he tell you, if anything, about setting child support in your case?
Objection, lady.
Overruled.
Well, on there he showed me making $40,000 more than he does. I was upset because it doesn't show the future earnings. I have a very stable and public pay scale, and I knew my ex-husband, he got hired at Delta when they were not hiring a lot of pilots, and now there's floods and floods of people, and his income has increased, but he didn't advise me that at the time that that was gonna matter, and that also I was scheduled to move the next June, and that I may not be able to complete the custody change and modification of custody prior to me moving out of the state of Nevada.
There's information in the fee agreement sent discussing a joint petition could be prepared for you. Did you read that?
I did.
Was that discussed? Withdraw. Shane said that was the issue of filing a joint petition was discussed with Bob Dickerson on July 2nd. Do you agree with that testimony?
I do.
Can you please tell the court what Bob told you about his ability to file a joint petition for both of you?
He said that he would be able to represent us and file a joint petition.
He would be able, did he say he would be able to represent you?
He would represent us both. We would pay him, and he would go to court, and we wouldn't have to go to court. He was acting as an attorney.
Did you inquire again about whether or not you would have to pay your own attorney to go to court or look it over? Did you inquire at all more, or you just accepted his statement?
Objection leading.
It is leading-ish.
Did you have any questions further about, after he said, I can do this for both of you, I can file this joint petition for both of you as your attorney? Did you have any follow-up questions?
Yes, I mean, I asked him how much time I needed to decide. I told him that I had already spoken to Willick Law Group, Mr. Willick and Mr. Creel.
Now let me be clear on this. Did you tell him on July 2nd or notify him later, because it's also in an email later? Do you recall telling him on July 2nd?
I told him,
Objection leading.
Just,
I'll withdraw.
you know what? There's a problem because it is leading.
Okay, I'll
'Cause you know,
withdraw
the one
and
thing that's missing from everything you're doing, and I'm surprised I haven't heard an objection, it's one of the more common objections, and that's a lack of foundation.
Yeah.
You've laid no foundation for any of this. I've been waiting for Mr. Cargione to say something.
Oh, I thought I did. I said, tell us what happened on July 2nd. We just started talking
Well, no, you
about
said, tell us what happened when you spoke with Mr. Dickerson.
on July 2nd.
No, you never said July 2nd.
All right, I would have to go back and I'll order the transcript, but I'm 80%, 90% sure. However, I think because you already have it in exhibits.
No,
you
actually,
already
that's an
did.
issue
So
in
I
the-
don't know what you.
That's an issue in the case.
Okay. All right. So are you confused? Are you lost? Do you want me to go? I want the court to not be confused as to foundation. Do you want me to go back? Because
I
July
want you
2nd
to-
was her first phone call.
I would like you to lay very specific foundation on this conversation.
Okay.
Yes, I would.
Okay. Tell the court, what is the first day you recall speaking to Mr. Dickerson?
it was
Do you
July.
mean separately?
No, my question is, when do you recall speaking with Mr. Dickerson for the first time in your life?
I spoke with Mr. Dickerson on July 2nd. My ex-husband,
Wait, tell me the year, tell the court the year so we have a clean record.
2014.
Okay. Did you talk to Bob Dickerson on any day prior to July 2nd, 2014?
No, my ex-husband had already had a phone conversation with him.
When you spoke to Bob Dickerson on July 2nd, 2014, do you recall where you were physically located?
Yes, absolutely. We had a cell phone on speakerphone, and we were upstairs. Our bedroom had two parts. There was like a bedroom and then an office. And we were sitting in the office on the speakerphone, and once Shane had answered all of his questions that he wanted from Bob, and he had already had a conversation with him, I took the phone, and I walked downstairs, and we had a spare bedroom we used as a workout room. And I remember closing the door and standing in the corner to talk to him and tell him all those things that I know Shane wouldn't want me to disclose. And staring at the door to make sure I didn't see the shadow of his feet, standing outside and listening to me.
So at that time, were you not really, did you think you had some right of privacy in that conversation with Bob?
I felt that I was owed some private time if this person was going to act as our attorney, that he should hear what my concerns are.
And who do you recall, whose cell phone, who dialed up the call on that July 2nd, 2014?
I believe it was Shane's, but we always had the exact same cell phone. I can see what it looked like, but we always had the same phone.
But there's been testimony that there was Bob thought it could have been a three-way phone call.
Yeah.
Does
No,
that make sense to you?
it makes absolutely no
Why?
sense because we were in the same room together. We wouldn't be both on a conference call.
Okay. And, so you're on, is that sufficient foundation to understand the, okay. So go ahead and tell the court, after the phone, how long do you estimate the phone call, whether part of it was separate or all together, from start to finish on July 2nd lasted between Bob and the both of you?
I would say 50 minutes to an hour.
Okay. And
How much to an hour?
50 minutes to an hour, perhaps.
okay. And at any point during this process, did Bob offer to, well, you already stated he offered to be your attorney. Did he provide you with any information he needed further in order to do your filing?
Yes, he.
Objection leading.
Overruled.
Mr. Dickerson wanted all of our financial information, all of our accounts, all of our property and vehicles.
Did you give any verbal, either of you besides that blurb that he had written, do you recall giving, what kind of verbal report do you recall giving to Mr. Dickerson about the custody issues?
Objection asked and answered.
That's
Lack of
not leading
foundation.
counsel.
If she's,
I said asked and answered and lack of foundation. I didn't say leading.
if there's any additional information you have not already shared with the court about the custody issues.
Overruled.
Again, I was just really concerned with the current schedule, how that would make custody happen. I am a military pilot. I'm home every single night, even though I fly airplanes where my son's father is gone for days at a time for about half of the month. I knew that no matter how the court saw us having joint physical custody, that I would be the primary physical custodian. I didn't want to fight him for legal custody, but I just wanted to be entitled to the, I don't know what the good word is, have the way the paperwork suiting the way that I knew things were gonna go. As long as he was flying for an airline, he's gone half of the month.
Did you share this concern with Mr. Dickerson
Absolutely,
during the phone conference?
absolutely.
And, is the exhibit books up there?
Yes.
If you look in the white book, exhibit 7, that's been admitted into, actually, look at exhibit D first, which, right on the first page there. When, this has been admitted into evidence, when did you give,
Are we exhibit 7?
exhibit D, when did you give Shane authorization to contact Bob and agree to let him be both of your attorney and file the joint petition?
Objection assumes facts not in evidence.
It's in evidence, exhibit D.
Lack of foundation. Leading.
I think you need to rephrase counsel.
Okay, take a look at exhibit D.
Because you're using language that presumes my ruling.
Look,
By the way, for the record, video's out again. Audio's okay.
that's why we couldn't find it. We were trying to like review part of it today.
Oh, is that right?
Yeah.
I can't
Well,
help.
it was
Is that
on
all
yesterday,
departments?
but right now it's showing the picture is out, but it's.
But the audio's still on.
Recording audio.
Okay. Because we had like 9 clips from yesterday, and I don't know if we made that many breaks or what happened. I know because we
We
tried
made a
to.
lot of breaks.
We couldn't even get it to work from the video prototype. But anyway, so go ahead and take a look. Is it? This letter's already been admitted in evidence. Can you tell the court when you had discussions with Shane about settling your case?
After we received the legal advice from Mr. Dickerson, we were able to get together and make quite a few decisions. There were still some big ones that I was uneasy with, but I went off of the advice that I got at the time.
It says here pretty much every issue, including division of assets and custody. So Was it child support and alimony, the same issues, the child support now, the sticking point in the settlement at this point, as of
Objection.
July 13th?
Objection leading.
You're leading.
Okay. What
Requesting.
issue, if those issues were pretty much resolved, do you recall what was left for you to either agree with him or?
There were no alimony issues since we were fairly equal earners, and we each had our own careers. I'm surprised that Shane wrote to him, and I was on that email too, that said we had agreed on custody. With my move coming up, I felt like I didn't have a choice at the time, and after the legal advice I got from Mr. Dickerson, we were able to make some initial decisions on how we were going to proceed with the divorce, but I was still uneasy, and that's why you see here that I moved the appointment back to the 30th.
Okay. And so, is this email from July 13th from Shane factually true as it is stated? We have reached agreements, and we would like to use your services to complete the necessary paperwork to file the joint petition. Was that a true statement made by your husband at the time it was written on July 13th?
Yes, it was.
So you had agreed with Shane on or prior to this date to use Bob Dickerson as your attorney?
Objection leading. Lack of foundation.
I think you can avoid a buzzword and make the question a little bit less objectionable.
I think she answered. You didn't send a letter in opposition and correct your husband that you didn't agree to use Mr. Dickerson to prepare the joint petition as your attorney, correct?
Objection.
Counsel,
Did
again,
Okay,
if I get
I'll
approach
rephrase.
counsel,
Did you?
approach counsel.
I've never gotten.